talk, everybody listen. Say hate, hate, hate cookie. Latest gossip, television shows, yeah, you know I'm spilling. Random documents, facts don't lie. Tune in, drop it in the chat, don't be shy. And let's talk about it. Welcome to Tater Tot Lane, come ride with me. Hot tea, real talk, yeah, that's the key. So tune in, let's talk about it.
Y'all get on back over here. Oh my God. It's really dark. I literally just left from outside and it was just bright and just hot as hell. Now it's and it's not even storming yet. So, but it's just really dark. And the power is flickering. Oh Lord. Okay, y'all back. Y'all come on. It's still flickering. Y'all, we might have to postpone. Oh, child. Oh, let me plug my damn phones up. Okay, y'all in, y'all coming in, come on in. Oh, yes, there go the birthday girl. Happy birthday, Pilot. Where's Stephanie? Oh, Stephanie in here. Happy birthday. Y'all tell Paulette and old Stephanie, have the birthday twins. Happy party. Oh, Cookie, get on. So messy. I'm trying to look outside, but one of my cameras is offline. Oh, yeah, it's starting to storm now. Okay, let me hurry up and get through it. Let me try to hurry up and get through it, y'all. Okay. Let me go back to the document really quick. Share my screen. Happy birthday, y'all. Whew. Oh, that's not it. Oh, that's her emotion. Okay, this is their emotion. Let me share this. Okay. I'm going to have to change the other video to part 1, and then I'll, this will be part 2, okay? Because I don't want to revisit what was on the other video, okay? So here we go with, I'll go back to maybe 11 because maybe y'all didn't hear that part. So we on 11. On March 31st, 2026, the federal court dismissed the respondent's federal lawsuit with prejudice and ordered respondent to show cause as to why she should not receive citations for citing non-existent cases or citing exaggerated or inaccurate holdings for existing cases. So y'all know that when she was putting those cases in on when she was putting those citing those cases in the what do you call that? When she was citing those cases in the lawsuit, they didn't exist. She was just making them up like a fucking creep. Like a real life creep. Okay? Well, I'm just trying to turn my monetization back on, y'all. Let me see. Put this thumbnail up here. And the judge caught on to it after one, I think it might have been Google or TikTok. They were like, this case doesn't even exist. And in this case, they was like, this case shows that this happened with the person and not like what she was trying to use it as a reference to what, to support her argument. The case went against her argument. So she just was making up shit. And so I guess that probably put the judge on notice, like, Check out some of her other stuff and her other cases that she was citing. The judge was determined that they either didn't exist, she was misquoting them, or she was just exaggerating facts on them, which is, again, unethical behavior, misconduct. Okay, let's get back to it. 12. On April 16th, respondent filed her response to the order to show cause in the federal lawsuit. And when her response was just that she may have made some mistakes, just as, honest errors. Not that all of her shit was wrong, but she just made honest errors in all of her citations, okay? 13. On May 19, 2026, the federal court issued an order finding respondent violated Civil Rules of Procedure 11B and issued sanctions against respondent in the federal lawsuit. 14. On June 9, 2026, respondent filed a notice of appeal in the federal lawsuit, okay? 15. On June 26, 3 days after she filed the respondent's motion to dissolve, 3 days after that, she filed respondent's motion to dissolve interim suspension and dismiss proceedings with prejudice in the instant case. Respondent filed a motion for leave to appeal in forma, I don't know that word, paperas, in the federal lawsuit, meaning that she tried to get her do her appeal without paying the fees for it. The judge denied the shit and said that anything that she put in the court, anything that she submit to the court is not in good faith. And the judge also told her not to send any motherfucking thing else back to that fucking case. Anything else that she got to say to the court, she got to send it to the 8th appellate court. Don't come back to me with this bullshit. Okay? 16. As of this filing date, respondent continues to represent herself in the federal lawsuit. She remember when a little birdie, tweet, had sent those attorneys, those corporate attorneys that was on the case, the email that shows that her license was suspended, and then one of the attorneys filed a thing with the court, alerting the court that she had not alerted the court that her license was suspended, when she was supposed to do that in every active case that she was in. She was supposed to alert those courts that her license was actively suspended at that time as of October 10th. She hadn't done that in that federal case. 17. On June 26, 2026, informant filed an information, pursuant to Rule 512A and C, charging respondent with multiple violations of the rules of professional conduct. These charges included conduct in the motion for interim suspension, as well as new allegations of professional misconduct discovered through informant's continued investigation since this court suspended respondent from practicing law in the interim. 18. Respondent has not yet filed her answer to the informant's information. Argument. 19. Respondent argues her due process rights have been violated in that she has been deprived of a property interest without due process, and because contrary to Rule 514 and 515, and despite the passage of more than 8 months, no disciplinary hearing panel has been assigned and no disciplinary hearing has been set on the charges against her. 20. This argument is fatally flawed, as these rules do not apply to an information and motion for interim suspension pursuant to Rule 524, but rather apply to an information filed pursuant to Rule 512, which they just did the 512. They just did the 512 on 6/26. So those rules with the time frames for the disciplinary hearing and all that type of stuff, that's for 512, the one that they just filed last week, not this one that they filed back in September. Okay, the 524. 21. Additionally, respondent has been afforded due process through Rule 524, which is the one that suspended her license. 22. In cases concerning the emergency suspension of a professional license, procedural due process requires a respondent is provided notice that is reasonable calculated under all circumstances to apprise interested parties of the pendency of the actions, and the respondent receives the opportunity to be heard at a meaningful time and in a meaningful manner. And they actually cite a case that's actually, a real case they cite. Okay. So don't get it twisted. A real case that they are citing. All right. And then they have, make sure y'all hitting the like button. Okay. In attorney discipline matters, 23, in attorney discipline matters, a respondent claims that they have been denied a valuable property right without the due process of law is without merit. Rule 5 affords a respondent due process. And they give another case study. This court further opines that if there has been a faithful following of Rule 5, a respondent has received due process. 24. Rule 524 allows the Chief Disciplinary Counsel to file an information with a proposed order of interim suspension with this court if there is sufficient evidence demonstrating that there is probable cause to believe that a lawyer is guilty of professional misconduct or is unable to competently represent the interests of the lawyer's clients, and evidence that the lawyer poses a substantial threat of irreparable harm to the public. Rule 524. And I told y'all that I put this, hey, Miss Cheryl, I put this in Veronica. I put this in my complaint to the OCDC on this batshit crazy ass attorney or ex-attorney. I put that in my complaint because they gave her mitigating circumstances in the last discipline that she had for misconduct back in 2020. They gave her, I think it was 2020 or 2022. They gave her this mitigating circumstances because she said that she had some mental illnesses that had been undiagnosed, that was just diagnosed at that time, which I find a hard time believing, but we're going to go with it because they gave her the opportunity to rehab the situation. So they just suspended her and they didn't disbar her because at that time of that disciplinary hearing, the judge was asking, why are we not talking about disbarment here? And they get, they said because her, I guess her father being sick and her being under pressure with her father being sick, that triggered 3 undiagnosed mental health disorders. Okay. Hey, love key. So they gave her a second chance, basically. All right. She didn't use that second chance to her advantage. What she did was up the damn ante and feel like she can use that mental health shit to get out of all of the other shit that she's doing. Now, do I agree? Do I think that she's honestly mentally ill? I do. But is her mental illness causing her to do these things? I don't. Also, she's very manipulative. And sometimes people with mental illnesses, sometimes they're very manipulative and they use their mental illness as a clutch so that they can excuse their poor behavior. Okay? And this is one of the reasons why I feel like they're going to disbar her this time, because they can't release her. They say she's a threat of irreparable harm to the public. She's not safe to the public. As an attorney, you have access to certain databases and things like that. And it's not safe for her to have that type of access to people's personal information because she is a fucking stalker. This bitch is still sending me motherfucking paperwork from the court. And it has attorney at law that I was directed to send to the OCDC today. Yes. She is still sending me court documents from the federal court that I've been terminated from for improper service. Like, she's creepy as fuck. 25. Rule 24A requires informant make contemporaneous a reasonable attempt to provide the lawyer with notice that a proposed order for immediate interim suspension has been filed with this court. 26. Rule 24B requires that this court be considered any response the respondent files with the court prior to a ruling. 27. If this court finds probable cause, Rule 524 permits this court to enter an order immediately suspending the lawyer pending final disposition of a disciplinary proceeding predicated upon the conduct causing the harm. Okay, that's Rule 524B. 28. Rule 524C allows for a respondent, and she's the respondent, who has been suspended pursuant to the rule to appear and move for dissolution or modification of the order of suspension. 29. Rule 524D as in dog then allows a respondent who is suspended pursuant to Rule 5.24 to request an accelerated disposition of the allegations forming the basis of the interim suspension by filing a notice with this court and serving a copy of the notice to the Chief Disciplinary Counsel requesting accelerated disposition. If the notice is filed, the matter shall proceed and be concluded without appreciable delay. So before she even filed for dismissal of the shit, she's supposed to follow this rule here and request that they accelerate the disposition, because what she's saying is, hey, DT, everybody, what she's saying is that she cannot make money as an attorney while her license is suspended, and it's taking so long, about 8 months now. But motherfucker, you wasn't making money as an attorney before. All you were doing was using your license to stalk and harass people on YouTube and other social media sites. Can we be clear on that? Hey, who said that? Hey, Indigo, y'all, welcome back. Welcome back. We're talking about the disgraced attorney that's y'all about to see what the OCD is doing with them. They have responded to her request to dismiss the complaints against her and to reinstate her license. Okay. So welcome back, everybody that's coming back in. 30. Rule 524, the rule under which respondent was suspended in this proceeding does not impose a time standard in which informant must file a Rule 512 information. Okay, that's the one they just filed on the 26th of June. Instead, the procedural remedy for any perceived delay is filing the Rule 512. Information is provided in Rule 524D, which allows for an expedited disciplinary proceeding only if requested through a filing with this court, and a notice of which must be served on informant. That hasn't happened, right? Hey, Ms. Gill at night. 32. Respondent has never requested an accelerated disposition of the allegations forming the basis of the interim suspension. Thus, the time standard of the proceedings and concludings without appreciable delay has not been initiated in this matter. So please go sit down. Still not following the rules. Rule 5.24 afforded respondent due process in that informant alleged respondent has violated rules of professional misconduct and posed a substantial threat of harm to the public. Respondent received notice of the filings of the interim motion to interim suspension. Respondent was heard on the issue through her answer, and it has been adjudicated by this court that there is probable cause that respondent is guilty of multiple instances of professional misconduct. Okay, is unable to competently represent the interests of her clients and poses a substantial threat of irreparable harm to the public. You see, they keep focusing on that as well. Okay. 34. As respondent received notice and had the opportunity to be heard on the matter before adjudication, respondent could have sought relief in requesting an expedited process pursuant to Rule 524D, but chose not to. 35. Respondent's reliance on the time standard in Rule 514 and 515 is misplaced. Don't know the rules. 36. Rule 514 states, within 15 days of receipt of a timely answer, the chair of advisory committee shall assign the matter to a disciplinary hearing panel and designate the presiding officer. 37. A Rule 5.24 information and motion for interim suspension is filed with this court, not the advisory committee. Only a Rule 512 information is filed with the advisory committee. Due to that distinction, Rule 514 can only apply to a Rule 512 information rather than a 524 information and motion for interim suspension. I'm starting to think that maybe her daddy, hey Shanice, this is anonymous stalking ass. Y'all remember the disgraced attorney that's been suspended? This is about her suspension. She requested to have it dissolved. I'm starting to think that her father took them law license for her, because it don't seem like she know none of the damn rules. Except when she claims somebody doing it against her. Okay? Additionally, 38, disciplinary hearing panels only hear cases after receiving a Rule 5.12 information, which is what they filed on 6/26 last week, not a Rule 524 information and motion for interim suspension. Further supporting Rule 514 does not apply in this instant matter. 39, finally, Rule 5.24 does not require an answer to the information and motion for interim suspension. An answer is only required for a Rule 512 information. See Rule 512.5. The respondent shall file an answer or other response with the chair of the advisory committee. As such, Rule 512 is not applicable to the Rule 524 information and motion for interim suspension. So this does not apply. 40. Informant has filed a Rule 512 information with the advisory committee. So they ready, y'all. They are ready. They're ready. As of the filing of this response, respondent has not filed her answer. Rule 514 has not been triggered in that matter, and it requires the disciplinary panel to be appointed 15 days after the answer is filed. Any claim under Rule 514 regarding the Rule 512 information, therefore, is premature. 41. Rule 515 states in part, the presiding officer of the disciplinary hearing panel assigned to hear an information shall set a date for the hearing that is no more than 60 days from the date the matter was assigned to the panel. The hearing should be concluded within 120 days of the assignment of this matter. 42. Again, disciplinary hearing panels only preside over Rule 512 informations. As such, Respondents' reliance on Rule 515 in the Rule 524 information and motion for suspension is misplaced. 43. Additionally, because respondent has not filed an answer to the Rule 512 information, any claim under Rule 515 regarding the Rule 512 information is also premature. So she can't impose Rule 515 without an answer to the Rule 512, and they just filed that on 6/26. 44. Since respondent's suspension since the respondent's suspension in the interim ordered by this court, respondent continues to violate the rules of professional conduct and poses a substantial threat of irreparable harm to the public as evidenced by her ongoing conduct in the federal lawsuit. Okay? Y'all see this shit? 45. Respondents continued misconduct. Listen to this one, because this is the part I wanted y'all to listen to. Respondents' continued misconduct in the federal lawsuit has resulted in additional investigation and additional charges in the Rule 512 information filed against respondent. The additional investigation was necessary to ascertain that breadth and extent of respondents' continued misconduct. Y'all see that shit? I told y'all this what was taking this mother so long. This what was taking them so long. They have additional investigations. They have been investigating this motherfucker, and they see they've been on that docket in that federal lawsuit. They've been on that docket. They see that this motherfucker continues to say, fuck what y'all talking about. The law don't apply to me. She gonna do what the fuck she wanna do. Wherefore, informant respectfully prays that this court enters an order denying respondents' motion to dissolve interim suspension and dismiss proceedings with prejudice. They want them to dismiss her shit, deny it. Maintaining the interim suspension imposed pursuant to Rule 524 during the pendency of this disciplinary proceedings to protect the public. Okay? Allowing the disciplinary process to proceed as outlined in Rule 5 and granting such other and further relief that this court deems just improper. Respectfully submitted. Y'all see this? Batshit crazy. Are you cool? Let me give it to her because she needs this on here. But I'm gonna put the special one that Britt made me. Okay, this one right here. How is you cool? How is you cool? How is you cool? And I don't know if y'all know that, but that little number that's on that shirt with the X in it, that's Sarita McNeil's bar number. How is you cool? How is you cool? How is you cool? Okay, right, sir. We'll go off straight cool for the damn Cocoa Puffs. Like something is seriously wrong with her, and they're sick of her. Hey, baby girl, they're sick of her in this damn courtroom. So, you know what? I wonder is that other one, the new rule that they just filed, I wonder is that on this docket? Let me see.
Welcome to Tater Tot Lane, come ride with me. Hot tea, real talk, yeah, that's the key. So tune in. Let's talk about